Local Planning Panel meeting. On behalf of the panel, I recognise the traditional custodians of the land and Ku-ring-gai people on whose land we meet. The meeting will be held in conferencing technology, and the Ku-ring-gai Council doesn't accept any liability for statements, comments or actions made by individuals. They'll be recorded, but an outside person must not use their mobile phone, video or any other means to record things. The on-demand viewing of the meeting will be available until the holding of the next meeting, and they're copyright protected forever. There are no apologies being received either from the staff or from panel members. I'll introduce the panel in a moment, the panel members in a moment. I'm the chair. My name is Angus Talbot. My alleged justification for being here is that I'm a lawyer and I spent some time working in this type of area, including 15 years as a judge of the Land and Environment Court. And I have two expert panel members assisting and one community representative. And I'll ask each of them to introduce themselves so that you understand who you're dealing with. First of all, Jacqueline Townsend, could you please introduce yourself?
Jacqueline Townsend, I'm a lawyer.
Thank you. Larissa Rozog.
Good afternoon, Larissa Rozog. I'm a town planner and done a Masters in Project Management, worked in local and state government and private practice for many years and sit on a number of panels.
Thank you, Larissa. Mr. Ian Arnott, community panel member.
Yeah, so my name's Ian Arnott. I am the community representative at this meeting, living in the Ku-ring-gai area. I'm actually also a town planner by profession.
Thank you. I asked each of the panel members to indicate whether they have any declarations of interest in respect of any of the matters that are before the panel today. Also,
No
conflicts.
Staff people who are relevant to the meeting, please also indicate whether they have any declarations of interest to make.
No declarations, Mr. Chair.
Thank you. I'll call each of the speakers in turn, with Mr. Busby going first. There will be Mr. Busby and Mr. Hughes. You will have 3 minutes, and we'll see how that works out. There will be some sort of indication at the conclusion of the 3-minute time to indicate to you that your time is up and you're expected to wind up as soon as you hear that. But as I said a moment ago, we'll hear Mr. Hughes first. Sorry, Mr. Busby first, being representing people who are against the opposite recommend. Wait a minute. No, it is the right way around. Mr. Hughes will go first. No, that's wrong. No, Mr. Busby's going first. Finally worked it out. So, Mr. Busby, are you ready to proceed?
Yes, that's fine. Can you hear me?
Yes, we can hear you, and your 3 minutes are starting now. Thank you very much.
Thank you. My greatest objection are the safety hazards that arise from the proposed use of the right-of-way. Also, the termination of our proprietary rights. What happens is on the north side of that driveway is the street number, 26A, and it's also the place where we put for sale, for lease signs. It's on our property, but if this plan proceeds in its current format, we would lose that part of the driveway because it would be the driveway would be widened. In terms of that widening, we, as unit holders of 26A, would not have legal access or right of use over that extra width. So we would only be legally entitled to use that side of our land. I've attempted to negotiate a reciprocal easement over the extra part, though those negotiations seem to have fallen foul or stopped. But I'm hopeful that we can resume that conversation. The next, or those negotiations, certainly in terms of getting a heads of agreement about how the construction is to go along, how our driveway access will be affected in terms of denied access for truck usage. Those trucks will probably cause significant damage to the water and power and internet services that travel under the driveway. Our driveway at the moment has a 3.5 ton limit, and any large removal trucks or any heavy vehicles break those pipes, both on the footpath, where Sydney Water has made several repairs, and for the full length of our driveway. We also would lose full pedestrian access to our letterboxes and to the Pacific Highway. The other major issue of concern is that their plan would provide a closed gate at the bottom of the driveway, which would lead into their turnaround space. That gate would be closed for deliveries, and there's a lot more deliveries these days, as everybody's probably aware. Since the pandemic, everybody orders out. And there is nowhere for those visitors, for those delivery vehicles, to park or stop while they're making deliveries to either unit. That would then force them to park on our land where there is nowhere to park, which blocks our driveway, blocks our access in and out of our garages. The next part of that is that anyone turning into that driveway is not able to turn around safely. They would then once again have to drive onto our property to turn around. So we need somewhere where vehicles can turn safely at the bottom of the driveway without having to go onto our property and inevitably cause more wear and tear onto our parking area. It's not a heavy one. It's just a light bitumen seal. So heavy vehicles that come down there would just destroy our parking area.
3 minutes. The 3-minute signal's gone, Mr. Busby. I'll allow you another minute.
So we think that there should be further negotiations met, but they're the main criteria is that we have reciprocal easements for signage, which they've agreed is not unreasonable, reciprocal easements for use of the driveway, so it becomes a proper 2-lane highway, not just 2 lane for them and 1 lane for us, which would just cause more dangers and hazards. And the other thing is the relocation of our utilities, such as the water and telephone that currently run under the driveway. They would be crushed and destroyed in the course of this construction. So they need to be relocated, which we're also trying to negotiate with. In the time limit, that's my summary. Thank you.
Thank you, Mr. Busby. The panel might have some questions for you, but what I understand from what you're saying, that one of the impediments to the lack of owner's consent from your property is summarised, or the reasons for that lack of consent have just been summarised in your address.
That is correct.
Thank you. Mr. Arnott, have you got any questions for Mr. Busby?
No questions from me at this stage.
Thank you, Ms. Oswald.
Yes, I've just got one question. Can you just, Mr. Busby, just explain, I'm not a lawyer and maybe Jacqueline or someone else can go through this, but when you say this will result in a termination of proprietary rights, what do you mean by that?
So the driveway, the right of way, if I can describe it simply as I can, is about 12 foot wide.
Yes.
And 8 foot of that is sealed driveways, bitumen driveway. The other 4 foot, I think there's about 2 foot or maybe a bit more on either side. It is the loss of that land is our proprietary right. So whilst there is a right of way, legally speaking, over the entire width of the driveway, the whole driveway is not used as a driveway. Part of it is used for signage, for our for sale sign and our leasing signs. Once the driveway is removed, so we have a pillow, like what would you call it, a pylon? It's a stone, a brick, what do you call it, wall, if you like, and the number 26A is stuck on that brick pylon. That whole thing would be removed and nobody would be able to find where 26A is when they're travelling down the highway.
Right,
And also in that area, that's a little grass gardened area. That is where we put for sale signs and for lease signs. So that part, so our driveway where there is no driveway now would be widened and we would lose that space. So what we would need to do is have that proprietary right or that right transferred onto the neighbouring property, onto number 26, so that we can still put for sale signs and the number 26A, reinstate that. Now, in my conversations with the solicitor and the developer, they agree that that is reasonable, and in principle, they agree to that. But this plan does not accommodate any of that. And if it proceeds as is, then we have no we have no right to continue negotiating. They'll just walk all over us. They've not listened to anything we've said to date. And they only agreed to that on condition that we provide them a consent.
Yes, all right. I think we understand where the impasse lies. Thank you, Mr. Busby.
Thank you.
Good explanation. Townsend?
Just following on from that, just so I can understand, the 12-foot right of way, what's the use of that right of way?
It's to access our property from the Pacific Highway. Our property is a battle axe block. So when you turn into the driveway, on the left is a garden bed that's probably about 2 or 3 foot wide. And then on the
no, sorry, I understand that. I'm just trying to get to the terms of the right of way. Is it just for access?
Yes.
That's it.
Yes, just right of way pertinent to the land.
So how you're using it now is just how you're using it, but it's not actually the right of way only really grants access. That's all.
Yes, so they can't stop. They can only travel over it to access their land. So at the moment, there's a hospital on it, and on average, they organised that there would only be 3 or 4 deliveries a day because they would have to pull over on their land to unload.
But there's no conditions.
No,
there's no conditions. So
No,
the right of way is simply access.
Yes, it is. Yes. Sorry, I'm a lawyer too, and when I say pertinent to the land, that just means that there's no limitations. It's just a free right of way.
Right.
So they can walk over it, they can drive over it, they can pass over it, but they can't stop or block or do anything like that. But inevitably, people do. People just park and stop there for convenience. They don't consider other people. And when people are now parking on their land, there's nowhere to stop. They just stop on our right of way, and then we can't access our property.
Okay, thank you. I don't have anything further.
Yes, thank you, Mr. Busby, for your assistance, and the panel certainly will be taking into account the observations that you've made.
Thank you.
Now I call on Mr. Lee Hughes. Are you there, Mr. Hughes? And ready?
Yes, I'm ready.
Good, thank you.
Okay, thank you for this opportunity. We've since the planning report was uploaded to the portal, we've spent the last week or 2 weeks looking at each of those 16 items. The main obstacle, as has been pointed out, that we've had or frustration over the last little while has been getting consent from the adjoining owners to even lodge the DA. I'd just like to correct a few things. We certainly have, I'm the applicant, but I'm speaking on behalf of the site owners. They have reached a broad heads of agreement that was held on site, and the items that were raised by Mr. Busby were certainly raised. It should be noted that on our site plan, we certainly have the intent of allowing for an additional right-of-way in favour of 26A to increase the width of the driveway to 5.5 metres of passing width, plus landscape on the southern side of that, which we've agreed to re-landscape on behalf of the owners of 26A's satisfaction. We've also agreed and have shown on the DA plan a footpath that we're also proposing to put a right-of-way servicing the pedestrian ramp at the back of our right-of-way that leads to the ramp that goes to 26A, and we'd make that accessibly compliant, so wheelchairs can actually get up that ramp. At the moment, there's a step at the bottom, so it's not actually possible for wheelchairs to actually get to the ramp. We've also included on our DA plans that we would be concreting that driveway, and we would also require, as or not require, we've also offered to relocate the services to a suitable depth and concrete over them so that there shouldn't be any adverse impact on loading. Each of the other items, we've actually reworked the drawings and resubmitted on Friday last week because we weren't sure when we were going to get that approval to lodge the DA, which we received on Friday. So I've uploaded to the portal revised drawings that we believe tackle each of those physical constraints that or concerns that council raised in the report. And as such, we'd like the opportunity to defer the assessment of this DA to next month so that council can reevaluate the modifications that we've made to the design such that they might be able to change their recommendation. The
deferral you mean is the deferral of the panel consideration?
Yes, that's right. That's right.
And thank you, there's the 3 minutes. There'll be some discussion now. Mr. Hughes, there's, of course, the difficult problem of the fact that the DA is not a DA until such times as the owner's consent has been endorsed. Despite all those expectations that you have, it doesn't solve the problem in terms of the panel being in a position to consider the DA. You've been indulged to date.
Sorry, can I just add the letter of approval to lodge the DA was sent through on Friday, so council has that on file.
Through to us, we'd have to be satisfied that the land that the consent covers is the appropriate land. But that's encouraging to think that at the next meeting, the consideration will be whether or not if you're granted the deferral, whether or not the responses in the amended plans satisfy the objections that the council has raised so far as the panel's concerned. So that we're neither in a position to have any consideration of the merits of what you might be proposing, and hopefully you overcome the technical impediment into the lodging of the DA. You've been indulged to date by council by considering, so there's been something happening there in that respect. But the fact is that you say an actual consent has been lodged. Is that so?
Yes, that's right. It was emailed to
is it an absolute consent?
Talia Andrew.
Is it a conditional consent or an absolute consent?
No. It consents to the lodgement of the DA.
If I may, it consents to the lodgement, but does not consent to the DA as it appears at the moment to the existing development application.
Absolutely, and we made that clear upon trying to get the approval to lodge the DA that it did not affect their right to object to the DA.
Well, that doesn't get us very far. If the DA that's been presented is not consented to, there's an impediment to dealing with the DA.
No, the problem that, as we understood from council, was that because we are using the right of way as part of our access to the site, that we needed approval from the adjoining owner for lodging the DA.
Yes.
Which has been received and forwarded to council and uploaded to the portal.
I see. All right, well, that'll all have to be dealt with when we see it. At the moment, we're not going to make any observations either about the consent, whether it's appropriate, or the merits, because it would be inappropriate for the panel to make any observations in regard to the merits, while ever there's a prospect that the matter won't be determined today. The panel will have to give some consideration to whether or not it's appropriate to defer and we'll consider what you put to us in that regard, and maybe have some regard to what has been received in terms of the consent. But I'll just see if any of the panel members wish to make any inquiry from him. Ms. Ozog?
Yes, I did want to ask. I just wanted to, so can I just confirm with you, Mr. Hughes, that with the proposed widening of the driveway and the footpath, that obviously would then be a change to the kind of the legislative requirements of that right of way. So you would be providing that area to still be a right of way, right of access, where the arrangement would have to change on title, obviously, to accommodate that. So then 26A can utilise the larger driveway and that footpath.
We're actually proposing that the existing right of way doesn't change in any form, and we
Right.
create a new right of way on our land
Okay.
alone, that
Yes.
favours 26A for vehicular and pedestrian access. We've also allowed for the creation of a zone 2 metres by 1 metre in addition to that right of way for the erection of for sale signs, etc. In the heads of agreement that was discussed and agreed to on site, there was also a relocation of the letterboxes further back from the intersection, which we have shown on a heads of agreement drawing that was sent to the body corporate of 26A. It also nominates the extent of the concrete driveway, and it also nominates the landscaping requirements. There is also some a note on that drawing, which I'm happy to send through to council as well as the panel, just highlighting the proposed heads of agreement. It also says that the relocation of the letterboxes is subject to approval by Australia Post.
Mr. Hughes, do you say that the preferred plans address each of the mirrored issues that have been raised?
Yes, I do. I believe that.
I see. Ms. Townsend?
I just want to follow on. I just want to confirm. So the current right of way, I believe it's just it's for access. So that's not going to change.
No.
So
normal pass and repass, is it?
That's right. But at the moment, the driveway is only quite narrow, so it doesn't permit passing. It only permits passing, I should say, it only permits passing by travelling onto 26 land where the old loading dock for the nursing home was, and that then allows cars to pass. If there was that obstacle, what we're proposing is that will be a 5.5 metre wide driveway with, we can have a rollback curb onto the footpath to allow even a little bit more if you need, but it would certainly allow for AS 2890 passing on that driveway.
Hughes, let me warn you, you should provide for that now. We require it.
Sorry.
You said that you just indicated that you would be able to provide that if it was necessary. Well.
Oh no! Well, we're proposing that anyway. It's not. Yes.
Quite clear.
Yes.
You
True.
need to propose it. It's not a question of us requiring something. We'll be looking at what you've said.
One of those.
No, it's certainly provided on the plans as I stand.
All right. Sorry, I interrupted.
Yeah, that's okay, Mr. Chair. The only other question I had was that I note in council's report the clause 4.6 regarding the FSR. I'm just wondering, you're going to take you've taken note of that, have you?
Yes, we have, and we've adjusted that in the documents.
Thank you. That's all I've.
Have you lodged a 4.6?
Yes.
A new one.
I haven't, but I can get that arranged in the.
That'll be here to work out. I'm just asking if you have, and you say you haven't. All right.
No, that's right. We lodged the 4.6 for the original scheme, which is with council. That's right.
Yeah. It's just that if you're looking at council's report, there's just a few things there. If the panel decides to defer, that's
Yes.
all.
We've certainly updated the GFA calculations, and we can have those figures amended in the 4.6 and lodged immediately.
Well, I would imagine the existing 4.6 won't do the job if you've changed the plans.
Mm.
Anyway, that's a matter for you. Mr.
Yes.
Arnott, do you have any observations to make or questions to put to Mr. Hughes?
Just following on the issue of right-of-way, just you heard Mr. Busby speak earlier about vehicles, delivery vehicles and things that would need to turn onto their site.
Yes.
Is there an intention that the right-of-way enable that, or that there is some other means that vehicles would exit without having to go onto the neighbouring site?
No, we've shown in the DA plans as submitted that there is a 3-point turning circle at the end of the site within the existing right-of-way.
So there's no proposal to change from that?
No.
And can I just also on the right-of-way issue, you may have mentioned it, sorry if I missed, but the pedestrian footpath would be included in the right-of-way to enable pedestrian access to the rear property?
That would be in the new right-of-way created on 26.
Yes, they would
That's right.
cover that as well.
That's right.
And the terms of the right-of-way are for full and free access over.
Yes.
Just probably from my understanding, sorry, the issue of things like the letterboxes and signs and things like that.
Yes.
You said would be by agreement, despite what the right-of-way says. Is that right? Or
no, the right-of-way, as I understand it, not being a lawyer, but from what the solicitors have told me, we have free and unabated right over that whole right-of-way to access our basement. Currently, we're not permitted that because there is an electrical pole and the signage and the stone pillar that are all associated with 26A. We have offered to relocate the services and relocate the numbering and the signage for 26A at our cost and discretion. If that's not granted, then we will be taking legal steps to have them removed because they're prohibiting the free and unabated access to our site.
so sorry, can I just understand where you're proposing to have them relocated to? Is it outside of the right-of-way?
We're proposing to actually put the services in that new right-of-way that will be created for 26A. We're proposing to put them underground. So at the moment, it's a pole with an elevated electrical feed that runs to the back of the site. We're proposing to relocate that and take that back to the rear of the property. And then if we need to relocate the pole to the rear of our right-of-way where it doesn't obstruct any vehicles, then maybe that's what we need to do.
And what about letterboxes and opportunity for sale signs and things?
Well, the letterbox currently exists within the right-of-way. We've no objection to having to keeping it where it is. We're happy to relocate it, keep it on the same side well, in fact, we could relocate it to the other side of the foot, so it's off the footpath. Quite happy to accommodate that. And then that means pedestrians can actually stand on the footpath to access their
Need further amendments too, so let's not get too far down the track. So
Okay.
concerned. Mr. Hughes, in asking the panel for a deferral, I'm sorry, Mr. Arnott, do you finish?
Yes, I think so. It's just in terms of that letterbox issue, whether terms of right-of-way needs to be adjusted or not to accommodate it. I don't know, but legal advice would.
Mr. Hughes is clearly on notice,
Yeah,
one way or the other, that it's of interest to you. Mr. Hughes, in applying to the panel to defer the final consideration of this matter, how do you describe what the amended plans have done in meeting the reasons for refusal that the council published? Do you say you've redesigned, or is it argument?
We've adjusted the design to accommodate, like if we go through the basement, we've been able
For a
to.
general statement, I don't want to know the nuts and bolts.
Sure.
Have you addressed? I want to know whether you've amended the plans to meet the objections the council has raised, or whether you are merely putting the plans to demonstrate how something might be considered in another way.
Understood. No, we've adjusted the plans to either accommodate the physical element that was required or requested, or we have reduced the top floor, if you like, to accommodate that. We've adjusted the floor-to-floor heights without changing the height of the building, so we've done that internally.
So you've answered my question. There have been actual amendments made rather than token responses that are really accompanied by an argument as to why it should happen.
No, absolutely. We haven't argued any case.
Yeah, good. Okay. All right. Well, Mr. Hughes, I think what the panel will do now is adjourn for 10 minutes to determine whether there's a deferral, because that needs to be determined here and now. What?
You can do that next meeting. You can do that.
Yes, I know I can do it in the next meeting. I was going to bring the next meeting forward. All right, no, we'll proceed to our our actual panel discussion for determination as per the program. I was thinking there might be some reason that we needed to defer, because if we're not going to defer, then different issues arise. But anyway, that'll be a refusal. If we don't defer, it'll be a refusal as things stand. Must be a refusal because of the owner's consent question. All right, thank you, Mr. Hughes. I'm now closing the public meeting section of the meeting. The panel will reconvene to make a determination in relation to this and the other development application before it, and the outcome of that deliberation will be published on the council's website within the next 24 hours.
Understood.
Thank you. Meeting closed.
Thank you.